All right, so let's answer some common questions here. This is just some facts about 42 CFR Part 2. So the question was, when a patient has signed a consent form allowing disclosure to multiple parties, can the patient revoke consent for disclosure to one or more of the parties while leaving the rest of the consent in force? The answer to this is yes, absolutely. Under 42 CFR Part 2, I'm just going to refer to it as Part 2, a patient can revoke consent to one or more parties named in a multi-party consent form while leaving the rest of the consent in effect. In a non-health information exchange or an HIE environment, this can be accomplished simply by the Part 2 program indicating on the consent form or in the patient's record that consent has been revoked with respect to one or more of the named parties. So in an HIE environment, that revocation with respect to one or more of the parties should be clearly communicated to the Health Information Organization, or the HIO, as well as noted in the patient's record by the Part 2 program. So the Health Information Exchange, the HIE, is a generic term that refers to just a number of methods and mechanisms through which information can be exchanged electronically. And as I'm using it here in this lesson, the term Health Information Organization, or HIO, means an organization that just oversees and governs the exchange of any health-related information among organizations according to the nationally recognized standards. So to ensure compliance with consent requirements, an HIO should have policies and procedures in place for implementing patient decisions to give and revoke consent. Once a patient has revoked a Part 2 consent with respect to one or more of the parties, that revocation should be immediately communicated to the HIO by the entity that's obtaining the patient's revocation so that it implements the revocation decision and it no longer transmits that Part 2 program's protected patient information to those one or more parties. Part 2 does permit that a patient can revoke consent orally. So while oral revocations have to be honored under Part 2, SAMHSA actually recommends that the entity obtaining the revocation gets it in writing, or that somehow documents that revocation in the patient's record. Also, Part 2 prohibits a program from making a disclosure on the basis of a consent which it already knows to have been revoked. A program is entitled, however, to kind of act in reliance on a signed consent prior to a revocation, and such disclosure would not be improper. But SAMHSA does recommend that a revocation be communicated as soon as it's practical to any entities that are relying on that consent. Also, the HIPAA privacy rule needs to be considered as well. The next question is, does a consent form allowing for a program to disclose Part 2 information remain in effect when the disclosing program merges with another, or if it undergoes corporate restructuring? Well, whether a consent form remains in effect when a program merges with another program or it undergoes corporate restructuring kind of depends on how the entity making the disclosure is identified on the consent form. So under Section 2.31A1, the disclosing entity can be listed by specific name or general designation. So if a particular program is designated by a specific name as the entity permitted to make the disclosure, then the consent form would no longer be valid if the program's name is changed. So that would follow like a merger or a restructuring or for some other reason. And since the new entity is not identified as the same one that was listed on the consent form, if the disclosing entity is listed by a general designation, like any drug or alcohol treatment program that's affiliated with the XYZ HIO, then that consent form would continue to be valid if the program making the disclosure merges or undergoes some sort of corporate restructuring and assumes the new merged program is also an HIO affiliated member. But Section 2.19 sets forth the requirement when a Part 2 program is discontinued or taken over by or acquired by another program, as opposed to just undergoing a name change or restructuring. So this section just kind of provides that a discontinued program or one acquired by another program must purge patient identifying information from its records or destroy the records unless the patient consents to the transfer of their records, except to the extent that there's a legal requirement that the records be retained. Another question that was brought up was, may a Part 2 program disclose patient information to providers of on-call coverage pursuant to a Qualified Service Organization Agreement, or QSOA? Yes, they can. So a Qualified Service Organization, a QSO, they define it and list the different types of services that a QSO provides. And they further reference a Qualified Service Organization Agreement, or QSOA. So medical services are included on that list, and so a Part 2 program can enter into a QSOA with providers of on-call coverage. So a QSOA is a two-way agreement between a Part 2 program and the entity providing the service. In this case, the provider of on-call coverage. So the QSOA authorizes communication between those two parties. But the Part 2 program should only disclose the information to the QSO that's necessary for them to perform their duties under the QSOA. So the QSOA does not permit a QSO to redisclose information to any third parties unless that third party is a contract agent of the QSO, and it's helping them to provide the services that are described in that QSOA. And only as long as that agent only further discloses the information back to the QSO or to the Part 2 program from which the information actually originated. So if the QSO exists between the Part 2 program and an HIO for services rendered to the program by the HIO, then the agreement would not allow the HIO to redisclose that information to a third party like providers of on-call coverage. So for an HIO to redisclose Part 2 information to providers of on-call coverage that are not part of the Part 2 program, the consent form that allows the HIO to make the redisclosures to the providers of on-call coverage would be needed. And since on-call coverage arrangements are fluid and the identity of the healthcare provider who is providing the on-call coverage might not be known, the designation of the recipient could be something like the healthcare provider who's providing on-call coverage for the ABC treatment program. Like, that's what you would write on that form. So by designating the recipient as the on-call coverage provider, the requirement that the recipient's name or title be listed would then be met. So consent for disclosures to providers of that on-call coverage can be included in the same consent form that's used for other disclosures of patient information if the program so chooses. You could put all of it on the same form. An HIO can redisclose Part 2 information without the patient consent to the providers of that on-call coverage who are part of the Part 2 program, or if they're part of an entity having direct administrative control over the program, as long as the on-call providers need the information in connection with their duties that arise out of the provision of the diagnosis or the treatment or the referral of treatment services. So for any additional information, there's fact number 10, and this was published by SAMHSA, applying the substance abuse confidentiality regulations to health information exchange. You can find this particular link under the video in this section. The next question is, can a single Part 2 consent form be used to authorize patient information to be exchanged through the HIO system for different purposes, such as treatment, payment, disease management, or quality improvement? Yes, absolutely. So you can use one single consent form authorizing the disclosure of any Part 2 patient information to different recipients for different purposes. But Part 2 also requires a consent form to specify the kind and amount of information that can be disclosed to each of those recipients that are named in the consent. The amount of information to be disclosed has to be limited to that information which is necessary to carry out the purpose of the disclosure. So that's going to vary depending on the different purposes, that different people are being allowed to access to the information that you made available through that HIE. So the consent form would have to be structured to make it really clear what information can or cannot be given out to which recipients and for what purposes. So the HIE system has to also be designed to kind of limit the different recipients' access through the HIE to only the kind and the amount that the patient information or of that patient information that they need to fulfill that specific purpose for which they're being allowed access. So if it's within an organization, I've seen organizations do it like you have a system such as, I'll just pick one, ShareNote, and you have a lower level employee that's providing PP services, or so they're a subcontractor and they're providing PP services. And the therapist can see what the PP's notes are, but the PP can't see what the therapist's notes are. So it would be something along the lines of that, just restricting what access they have to the client's chart. The next question is, does Part 2 permit a healthcare provider to disclose information without consent when there's an immediate threat to the health or safety of the individual or the public? So Part 2 does permit the disclosure of information under certain circumstances without the consent. So this would be during a medical emergency or in some other limited situations. So if a Part 2 program or a healthcare provider that has received the Part 2 patient information believes that there's an immediate threat to the health or the safety of any individual, there are a couple of steps that I'm going to describe that the Part 2 program or the healthcare provider can take in such a situation. For notifications to medical personnel in a medical emergency, the Part 2 program can make these disclosures to the medical personnel if there is a determination that a medical emergency exists. So, for example, like there's a situation that poses an immediate threat to the health of the individual and requires immediate medical intervention. We had a client who had a seizure on property, and we had to immediately call the ambulance, and we were able to disclose the client's name, date of birth, any immediate health information that we had accessible for that client, emergency contacts, things like that. The information that is disclosed to a medical personnel who are treating the medical emergency may be redisclosed by that personnel for treatment purposes as needed, so they may have to tell the hospital, and then that hospital may have to tell a subcontractor or a nurse or a doctor. So for additional information regarding disclosures during a medical emergency, you can click on that link and look at number 7, 8, or 9. Also, when we're providing notifications to law enforcement. So law enforcement agencies can be notified if there's an immediate threat to the health or safety of an individual that exists due to a crime on program premises or against the program personnel. Now, if it's a crime that's being committed at the 7-Eleven, that's something completely different. But if it's happening on your program premises or against your program personnel, then you can disclose. You can't be someone's therapist and then the client is threatening to shoot you in the head and you're like, confidentiality prevents me from disclosing that to law enforcement. No, you are allowed to say, hey, there's a threat against my personnel, or if they say they're going to blow up the building, then you can report those things. So you are permitted to report a crime or an attempted crime to the law enforcement agency or to seek its assistance. Part 2 does permit a program to disclose information regarding the circumstances of the incident, including the name, the address, the last known whereabouts, and the status as a patient in the program. But that would be the only thing that you could disclose about their treatment. Also, we can disclose if there's immediate threats to health or safety that don't involve medical emergencies or crimes on the program premises or against the program personnel. So, this would be Part 2 programs and healthcare providers and HIOs who have received Part 2 patient information, they can make reports to law enforcement about an immediate threat to the health or safety of the individual, or if there's threats to the health or safety of the public if the patient identifying information is not disclosed. So immediate threats to health or safety that don't involve a medical emergency or crimes like a fire are not addressed in the regulations. So programs should evaluate these circumstances individually. Also, reports of child abuse and neglect. So there are restrictions on disclosures, but they don't apply to the reporting under state law of incidences of suspected child abuse or elder abuse, and also neglect. And we have to report those to the appropriate state or local authorities. But Part 2 restrictions continue to apply to the original alcohol or drug abuse patient records that are maintained by the program, including their disclosure and use for civil or criminal proceedings, which may arise out of the report of the suspected child abuse and neglect. So instead of saying, oh, I have a client here that is a crack addict, but they said that they were spanking their child too hard with a belt, we wouldn't need to disclose that they were a crack addict. We wouldn't say something like that. We would just say, my client has disclosed that they were abusing the child. Also, a court order under Part 2 may authorize disclosure of confidential communications that are made by the patient to a program in the course of any diagnosis, treatment, or referral for treatment if, for among other reasons, that disclosure is necessary to protect against an existing threat of life or of serious bodily injury, including circumstances which constitute suspected child abuse and neglect. For court-ordered disclosures, under the regulations, Part 2 programs or any person having a legally recognized interest in the disclosure which is sought can apply to a court order for an order authorizing disclosure of that PHI. So if there is an existing threat to life or serious bodily injury, the Part 2 program or any person having a legally recognized interest in the disclosure which is sought can apply for a court order to disclose that information. The next question is, under what circumstances can information disclosed pursuant to Part 2 be redisclosed? So once the Part 2 information has been initially disclosed, either with or without the patient's consent, no redisclosure is permitted without that patient's express consent to redisclose, or unless otherwise permitted under Part 2. So disclosures that are made with the patient consent have to be accompanied by that statement that notifies the recipient that the Part 2 redisclosure is prohibited, unless further disclosure is expressly prohibited by the written consent of that person to whom it pertains, or if it's otherwise permitted by Part 2. When disclosures are made without the patient consent, under a few circumstances, limited redisclosures without obtaining the patient's consent are permitted, like for medical emergencies, child abuse reporting, crimes on program premises or against the program personnel, and also court-ordered disclosures when the procedures and criteria are met under Part 2. So when these disclosures are made under those circumstances, the recipient is prohibited from redisclosing the information without consent, except under a few restricted circumstances, like for research. So researchers who receive patient identifying information are prohibited from redisclosing that information to anyone except back to the program. If we have an audit or an evaluation, Part 2 permits disclosures to persons and organizations authorized to conduct audits and evaluation activities, but it imposes limitations by requiring any person or organization that is conducting the audit or the evaluation to agree in writing that it will redisclose patient identifying information only back to the program or pursuant to a court order to investigate or prosecute the program, not the patient. So if the program's under investigation or prosecution, then that audit or auditor would be able to redisclose that information. Or if there's a government agency that's overseeing like a Medicare or Medicaid audit or evaluation, then redisclosure could be permitted in that situation. So how can a Part 2 program ensure that it's going to be notified that a healthcare provider invoked the medical emergency exception and gained access to protected Part 2 information? That's a great question. So the Part 2 regulations at 42 CFR 2.51 actually specify that when a disclosure is made in connection with a medical emergency, the Part 2 program must document it in the patient's record, the name and the affiliation of the recipient of the information, the name of the individual making the disclosure, and the date and the time of the disclosure, and the nature of the emergency. All of that has to be documented. You can't just go all willy-nilly and say, oh, it was just released to medical personnel. You have to put down who it was, their agency, the date, the time, who actually disclosed the information. All of that needs to be documented. SAMHSA actually recommends that the HIE data systems be designed to ensure that the Part 2 program is notified when a disclosure occurs, and Part 2 records are released pursuant to a medical emergency. So to promote compliance, SAMHSA recommends that the notification include all the information that the Part 2 program is required to document in the patient's record, like the date and time of disclosure, the nature of the emergency, etc. Also, SAMHSA recommends that the information about emergency disclosures be kept in the HIO's electronic system and protected using appropriate safeguards. So before a Part 2 program enters into an affiliation with an HIO, it should consider whether the HIO system has the capability to even comply with all the Part 2 requirements, including the capacity to notify the program when its records have been disclosed, let's say for a medical emergency. You can also look at that FAQS link and look at number 5, 8, and 9 for more information. So what categories of healthcare professionals are considered medical personnel for the purpose of obtaining information during a medical emergency? Well, Part 2 actually allows patient identifying information to be disclosed to medical personnel in a medical emergency, but it does not define the term medical personnel. It just merely provides that information can be given to medical personnel who have a need for information about a patient for the purpose of treating a condition which poses the immediate threat to the health of any individual and which requires the immediate medical intervention. So it's up to the healthcare provider or the facility treating the emergency to kind of determine the existence of a medical emergency and which personnel are needed to address that medical emergency. The name of the medical personnel to whom the disclosure was made, their affiliation with any healthcare facility, the name of the individual making the disclosure, the date and time of the disclosure, and the nature of the medical emergency have to be documented in that patient's record. And we talked about that a few moments ago, but you can look in the FAQS link that I provided under this particular video at number 5, 7, and 9 for more information about this. So, can the Part 2 medical emergency exception be invoked to head off a potential medical emergency, such as a potential drug interaction? Well, if a healthcare provider that's treating an individual determines that a medical emergency exists as defined in Part 2, like, for example, a condition which poses an immediate threat to the person, not just the patient, but the health of any individual, and which requires immediate medical intervention. And in treating that medical emergency, that healthcare provider needs information about potential drug interactions, then that information and any other information contained in the Part 2 record that the treating healthcare provider determines they need to treat the medical emergency can be disclosed. So, maybe they want to prescribe a or they want to administer a benzodiazepine. They would need to know if the client's been drinking, or if the client has been taking any benzodiazepines or anything that could negatively impact that particular medication. But if no such determination exists, SAMHSA recommends trying to just obtain consent from the patient first. If the healthcare provider is treating a patient in a non-emergency situation and that provider is concerned about a potential drug interaction, in an HIE environment, an HIO may only disclose a Part 2 program patient record to a healthcare provider if the patient consigns a consent form releasing the Part 2 record to the healthcare provider. Such a consent form may already exist if the patient previously signed a Part 2 consent form allowing the HIO to disclose Part 2 information to HIO-affiliated healthcare providers, and the provider seeking access is listed as a recipient on that form. So it's going to behoove you to already have that signed and know which healthcare providers are on call in your particular area. So a healthcare provider who is concerned about potential drug interaction and treating a patient in a non-emergency situation can also gain access to a Part 2 program's patient records if the healthcare provider has that signed QSOA with the patient's Part 2 program. And the information that we disclose is going to be limited to what is needed for that provider to provide services to the Part 2 program. And we're going to obtain the patient's consent. So in a non-emergency situation, if the healthcare provider is concerned about any potential drug interactions, if they are part of the Part 2 program or an entity that has direct administrative control over the program, then they can gain access to the patient's record without consent if the healthcare provider needs that information to treat the patient. So CFR 2.12C subsection 3 does not restrict communications between and among such personnel who have a need for the information in connection with their duties arising out of the provision of any diagnosis, treatment, or referral for treatment services. But it should be noted that just concern alone about potential drug interactions is not sufficient to meet that standard of medical emergency. So based on the circumstances of the presenting situation, SAMHSA just recommends that healthcare providers should obtain consent from the patient where it's feasible. So do all primary care providers who prescribe controlled substances to treat substance use disorders meet the definition of a program under Part 2? No. Not every primary care provider who prescribes controlled substances meets the definition of a program or are part of a program under Part 2. So for providers to be considered programs that are covered under the Part 2 regulations, they have to be both federally assisted and meet the definition of a program under 42 CFR 2.11. So physicians who prescribe controlled substances to treat substance use disorders are DEA licensed and thus meet the test for federal assistance. Nevertheless, the regulations establish additional criteria to meet that definition of a quote-unquote program. So if a provider is not a general medical care facility, then the provider meets Part 2's definition of a program. If it's an individual or entity that holds itself out as providing and provides alcohol or drug abuse diagnosis, treatment, or referral for treatment. And if the provider is an identified unit within a general medical care facility, it is a quote-unquote program if it holds itself out as providing and it does provide alcohol or drug abuse diagnosis, treatment, or referral for treatment. So you can either be an individual or you can be part of a program. And also, if the provider consists of medical personnel or other staff in a general medical care facility and its primary function is the provision of diagnosis, treatment, or referral for drug and alcohol abuse, and it is identified as such specialized medical personnel or other staff within the general medical care facility, then it would fall under that. So, in addition, in explaining Part 2's applicability and coverage, Part 2.12 subsection E, subsection 1 states that coverage includes, but it's not limited to, employee assistance programs, programs within general hospitals, school-based programs, and private practitioners who hold themselves out as providing and do provide that alcohol and drug abuse diagnosis, treatment, or referral for treatment. So, accordingly, primary care providers who do not work in general medical care facilities do meet Part 2's definition of the program if their principal practice consists of providing alcohol or drug abuse diagnosis, treatment, or referral for treatment. And if they hold themselves out as providing the same. So if their principal practice consists of providing that diagnosis and treatment, but they do not hold themselves out as providing those services, then it's likely that they would not meet the definition of the program. And the phrase holds itself out is not really defined in the regulations, but it could mean a number of things, like state licensing procedures, advertising or posting of notices in the office, certifications in addiction medicine, listing in registries, internet statements, consultation activities for non-program practitioners, information that's presented to patients or their families, or any other activity that would lead one to reasonably conclude that the provider is providing or it does provide alcohol or drug abuse diagnosis, treatment, or referrals for treatment. So while the term general medical care facility is not really defined in the definitions, hospitals, trauma care centers, or federally qualified health centers would generally be considered general medical care facilities. So primary care providers who work in these facilities would only meet Part 2's definition of a program if they work in a identified unit within that general medical care facility that is substance abuse diagnosis, treatment, or referral related, or if the primary function of that provider is the diagnosis, treatment, or referral for treatment of alcohol and drug use disorders, and they're identified as providers of those services. So in order for a program in a general medical care facility to share information with other parts or units within that general medical care facility, administrative controls must be in place to protect Part 2 information if it's shared. So is information generated by the provision of SBIRT, which is screening, brief intervention, and referral to treatment services, covered by Part 2? So SBIRT is just a cluster of activities that are designed to identify people who engage in risky substance use, or maybe who they might meet the criteria for a formal substance use disorder. So clinical findings do indicate that the overwhelming majority of individuals who are screened in a general medical setting don't have substance use disorders and do not need substance use disorder treatment. The determination whether the patient information acquired when conducting the SBIRT services is subject to Part 2 will depend on whether the entity conducting the SBIRT activities is a federally assisted program as defined in the regulations. So if that entity conducting the SBIRT services is not a federally assisted program, then those services and the patient records that are generated by those services would not be covered under Part 2. Although HIPAA and state laws may still apply there. But if the entity or the unit within that general medical care facility conducting the services is a federally assisted program under Part 2, then those SBIRT patient records would be subject to the Part 2 regulations. So what is Part 2's relationship to state laws? 42 CFR 2.20 states that no state law may authorize or compel any disclosure prohibited by these Part 2 regulations. But states can impose additional confidentiality protections, so they can go above and beyond. So Part 2.20 provides that if a disclosure permitted under these regulations is prohibited under state law, neither these regulations nor the authorizing statutes may be construed to authorize any violation of that state law. So would a logon or splash page notification of a HIO's portal that contains the Part 2 notice prohibiting the redisclosure be sufficient to meet the Part 2's requirement that disclosures made with patient consent be accompanied by such a statement? No. So Part 2 requires each disclosure made with written patient consent to be accompanied by a written statement that the information disclosed is protected by federal law and that recipient cannot make any further disclosures of it unless it's permitted by the regulations. So a logon page is the page where the user logs onto a computer system. A splash page is just an introductory page to a website. A logon or a splash page notification on an HIO's portal, including the statement as required by 3.2 would not be sufficient notification regarding prohibitions of redisclosure, since it would not accompany the specific disclosure. So the notification has to be tied to the Part 2 information being disclosed in order to ensure that the recipient of that information knows that the specific information is protected under Part 2, and it can't be redisclosed except as authorized by the express written consent of the person to whom it pertains, or as otherwise permitted under Part 2. So basically all of this is saying, if I log into my system, let's say ShareNote or Kipu or whatever, that login page is not sufficient enough because I'm the one disclosing the information. So if I disclose that information, then the person that's receiving it is not going to see my login page. They're going to receive the information. So maybe I printed it out and I sent it via mail. It needs, that notice of redisclosure needs to go with that information in the mail, or in the email, or in whatever portal. It needs to have that redisclosure message in there. So if a Part 2 program has signed QSOAs with 2 service providers, can those service providers redisclose Part 2 information to each other? No. A QSOA is a two-way agreement between a Part 2 program and the entity that's providing the service. So for example, a lab. So the QSOA authorizes communication only between the Part 2 program and the QSO. And the QSO, in this case, is the lab, would not be allowed to redisclose lab results about the Part 2 program's patient to another QSO, like an HIO, or even if the HIO has also signed a QSOA with the Part 2 program. In order for the lab to redisclose Part 2 patient information to the HIO, it would need the patient's signed Part 2 consent or be otherwise permitted by Part 2. So one consent form could both authorize the Part 2 program to disclose information to the lab and authorize the lab to redisclose Part 2 information to the HIO. You would have to have that on the front end, though. Once the HIO obtains the lab results, it could, through the QSOA it's signed with the Part 2 program, send those results to the Part 2 program, assuming that was a service described in the QSOA. So let's say we have XYZ treatment facility, and they're contracting you with ABC Labs. In order for any information to be disclosed to the HIO, ABC Labs would have to send it back to the treatment facility, and the treatment facility would then have to send it to the HIO. So if an HIO has a QSOA with a Part 2 program and a patient signs the consent allowing an HIO affiliated provider to gain access to the patient's records through the HIO, does the patient consent allow the HIO to disclose the Part 2 information? Well, yes. As long as the consent form is signed and it conforms to the requirements of Part 2, then yeah. But the QSOA does not allow a QSO like an HIO to redisclose Part 2 information to a third party except to a contract agent of the HIO if it needs to do so in order to provide those services that are described in the QSO. But if a patient signs a consent form authorizing that HIO, which has received the disclosed information from the Part 2 program, to then redisclose that information to a HIO affiliated member, then the Part 2 information can be redisclosed by the HIO. But that needs to be obtained in the initial consent form. So your consent forms need to be well thought out here. The Part 2 consent provision requires that a consent form include the specific name or general designation of the program or person permitted to make the disclosure. So we need to be specific or just general enough. In the case where Part 2 information is made available to an HIO, whether it's through that QSOA or written patient consent, that consent form allowing the HIO to redisclose that information has to identify by name or general designation the Part 2 programs as the entity permitted to make the disclosure of the Part 2 information. And that's because while the HIO is redisclosing the Part 2 information, the disclosing entity remains the Part 2 program. So the consent can also name the HIO as a redisclosing party. but the Part 2 program may be identified either by its specific name or by a general designation. But language such as all programs in which the patient has been enrolled as an alcohol or drug abuse patient, that would be an acceptable general designation. The next question was, under Part 2, can an HIO or an HIO-affiliated member use a consent form that generally designates the entities permitted to make disclosures of Part 2 information and refers to the HIO's website for a list of those disclosing entities? Yes, the consent form can refer to the HIO's website for the list of entities permitted to make disclosures if that disclosing entity is identified by a general designation in the consent form as permitted under Part 2. So Part 2's consent provisions allow either the name or general designation of the program or person permitted to make the disclosure, and it has to be specified on the consent form. Because a general designation is permitted, if that general designation is used, then the specific names of the disclosing entities don't need to be included on that consent form, and the patients can be referred to the HIO's website for a list of those entities. And this is in contrast to Part 2's consent provision regarding the recipients of the Part 2 data. So 2.31A2 requires that a consent form include the name or title of the individual or the name of the organization to which the disclosure is to be made. So it was previously noted in the regulations, but Part 2 consents cannot refer patients to the HIO website for a list of potential recipients of their data, but rather they must identify the consent of all the HIO affiliated members by name or title that are potential recipients of the Part 2 data. And that's in the ONC in 2010 applying for the Substance Abuse Confidentiality Regulations to Health Information Exchange PDF. So how does the Supreme Court's decision in the United States v. Windsor, which overturned Section 3 of the Defense of Marriage Act, affect 42 CFR Part 2? Well, that's a really good question. On June 26, 2013, in United States v. Windsor, the Supreme Court held that Section 3 of the Defense of Marriage Act, or DOMA, or DOMA, that actually they prohibited the federal regulation of same-sex spouses or marriages. They said it was unconstitutional. So, consistent with HHS policy, same-sex spouses or marriages are to be recognized in SAMHSA regulatory provisions. So what that means is a person or entity that's subject to SAMHSA's confidentiality regulation governing alcohol and drug abuse patient records, that policy also applies to you. So the regulation contains a provision that is affected by the Windsor decision, which addresses consent on behalf of incompetent or deceased patients, and it provides that in the absence of a personal representative, consent to disclosure of information identifying a deceased patient as an alcohol or drug abuse patient may be given to the patient's spouse, or if there's not a spouse, by any reasonable member of the patient's family. So SAMHSA now interprets that provision to include same-sex spouses in the meanings of terms spouse and family. So that means that for the purposes of that provision under Part 2, you are required to treat as valid the marriages of same-sex couples whose marriages were legally entered into. And that applies regardless of whether the couple now lives in the jurisdiction that recognizes same-sex marriage or a jurisdiction that does not recognize same-sex marriage. Any same-sex marriage legally entered into in one of the 50 states, the District of Columbia, or the U.S. territory, or a foreign country will be recognized. However, that does not apply to registered domestic partnerships, civil unions, or similar formal relationships that are recognized under state law as something other than marriage.